we're about to embark on contract law. Now, if you notice, contract law is covered over several different chapters. I've assigned 6 chapters for you. We're going to be looking at an overview first, which will get us a pretty good bird's eye view of all that we're going to cover, and then we will be focusing on the elements in chapters 12 and 13 for contract formation, agreement, and consideration, and then chapter 14, capacity and legality, and then chapter 15 about mistakes, and then finally how to get out from underneath to perform or to discharge. But feel free to peruse, to read for pleasure, or to even skim other chapters that have to deal with contract law if you are interested. And we are going to cover the common law kinds of contracts, although also know that sales and lease contracts are governed by the UCC. We have adopted that in Texas. And there's just a few little differences, but it's easier to understand the basics of contract law and then to learn the few little differences in the UCC. And also, the UCC is written in statutory, and you can easily pull it up to answer any questions you might have. We're going to be focusing then on common law contracts. And those also are the two sources, common law and UCC for contract law. So what's contract law for? It's about enforceability. That's what it's about. And you will see that in business, just to be organized, to plan, to lead out, to control, one needs to use contracts or contract-like things, agreements, to ensure a business runs properly. And I don't mean to be flippant, but even drug cartels use contract substitutes. Why they're not technically contracts is because they're not enforceable in a court of law, because sale of drugs is illegal. They have other ways of enforcing their agreements, if you can imagine. Here's a definition of contracts. It's a promise or a set of promises for which, for the breach of which a law provides remedy. So a promise or a set of promises for the breach of which the law provides remedy. Broken down, it is an agreement. It's formed by 2 or more parties who agree to a promise, where that promise is supported by consideration. So a contract can be enforced in a court of law, and that's why we have them. We want to make sure we have someone else who can come in and make the other party do what they said they were going to do. We use an objective theory of contracts, so we don't really give a flying flip what the subjective intent of an individual was in court. I now certainly do in business, but it's not about what a party said out loud when entering into a contract, how the party acted or appeared. It is about what's on paper. At least that's what we say. Whether or not that can be 100% in our dealings is another question, but we use the objective theory of contracts. So there are 5 elements of contract. Here are 4 of them: agreement, consideration, capacity, and legality. Sometimes there's a 5th element that is called form, and it must be in writing. But we require that there be an agreement and consideration to be a contract. And if you have agreement, which is proved by offer and acceptance, and you have consideration, and that consideration must be of legally sufficient value, and there must have been a bargain for exchange. If you prove those 2 up, you have a contract, assuming all parties were legally competent, they had contractual capacity, and the purpose was legal at the time of execution. It will be binding. Now, the way the textbook presents this is that they call voluntary consent informed defenses to enforceability, and I actually call form one of the elements that's only sometimes an element. And then voluntary consent, I actually think, is evidence that there wasn't a bargain for exchange. Right? So if you prove up a lack of voluntary consent, you're actually proving up that consideration didn't exist. So I consider this defense to be sort of an anti-element for consideration, and then I add form underneath this foursome list here to be 5. But it's okay the way your textbook presents it because it works the same way. If it's supposed to be in writing and it's not, that is a defense to its enforceability. It's a defense to the enforceability. So this is from your text 11-1. There are 3 toggle switches, and there's actually some more. We're going to focus on these. A contract, in its formation, a contract can either be bilateral or unilateral. It can either be formal or informal, and it can be either express or implied. So it's either going to be bilateral or unilateral. It's going to be formal or informal. And it's going to be express or implied. So a bilateral has to do with the way the offer or presents the offer. So the offer or gets control over whether it's bilateral or unilateral. So here's a question for you. Which one is this, or of which kind is this offer? I promise to pay you $500 if you promise to mow my lawn by Friday at 5. What kind of offer is that? I promise to pay you $500 if you promise to mow my lawn by 5 o'clock on Friday. That's a bilateral offer. It is a promise for a promise. Same scenario. I promise to pay you $500 if you mow my lawn by 5. I'm not looking for you to promise me back. I'm looking for action. That's a unilateral offer. So let me read them or say them again to you. In the first case, this first one's going to be bilateral. I'm looking for a promise in return. How can you accept my offer? By promising. In the second instance, how can you accept my offer? By action. Here's the first one. I promise to pay you $500 if you promise to mow my lawn by 5 o'clock on Friday. First example, a promise for a promise. Second example, I promise to pay you $500 if you mow my lawn by 5 o'clock on Friday. In that case, the second case, the unilateral offer can only be accepted by performance, by action. And we have formal versus informal contracts. A contract that requires a special form, like it has to be in writing, is formal. And informal has no such requirement. It's that simple. Then we have express and then implied in fact. An express contract can be oral or written, but the terms of the agreement are expressed. They are explicitly stated. Implied in fact is based on conduct, and that conduct is what creates and defines the terms of a contract. And a contract can be a mixture of both. You think about going to Target, you typically have a mixture of both when you buy a candy bar. There's part of the deal, part of the terms are written, probably the price tag, part of it or not. They're implied in fact. Then we have contract performance. So remember, we have these toggle switches of bilateral or unilateral, formal or informal, and then express or implied. Here's another toggle switch, and this has to do with where you are in the performance of the contract. You either have an executed contract or an executory contract. An executed contract, fully performed. It's been executed. An executory contract, there's at least some part that has yet to be performed. It's sort of up in the air. It's not fully executed. It's executory. We have a couple of other things to consider. A valid contract is redundant. A voidable contract is nonsensical. That is, there's no such thing, as a void contract, not avoidable. There's no such thing as a void contract. A void contract here is no contract at all. A valid contract is redundant because a contract is valid. But we're going to use the term valid, we're going to use the term voidable, we're going to use the term unenforceable and the term void to modify the term contract. So when we say a valid contract, that's like saying he is an unmarried bachelor. Well, bachelor means unmarried, and if it really is a contract, it is a valid contract. A void contract is like saying a married bachelor. It's nonsensical. It doesn't make sense. But it's helpful to us to use the term valid contract, voidable contract, unenforceable contract, and void contract. What we mean when we use those terms are this is a purported contract, and it's either going to be valid, voidable, or void. It's an alleged contract, and it's either going to turn out to be valid, void, or voidable. Unenforceable contract, a little different, and I really wish that your textbook would maybe put this in a little bit different uh, category. An unenforceable contract is a valid contract on its terms, it's good to go, but something else outside of the contract makes it no good anymore. It's a perfectly valid contract, but it's unenforceable for something outside of the contract terms, like a statute of limitations. You have a perfectly good contract. You wait 5 years to sue for breach of contract. It's going to be unenforceable because the statute of limitations outside of the terms say it's unenforceable. You only have 4 years. So here's a way to look at it. A valid contract is enforceable, which is redundant, voidable, which means it could go either way, or unenforceable, which was it used to be good, but you can't sue on it because of a legal defense. And then finally, a void contract, no contract at all. Void contract, it's nonsensical. Then we get to quasi-contract. Now, quasi-contract is a fictional contract, and it's not really a contract. Quasi-contract is not a contract. It's not going to be listed among those others. It's not a contract. It's a quasi-contract. It's going to be treated like there was a contract, but the judge is saying there ain't a contract. There is no contract here, but we're going to consider this a quasi-contract. It's as if the parties had entered into an actual contract. So don't get confused. When you see the word quasi-contract, it means there isn't a contract, but the judge is going to pretend or act like there was. It's fictional. It's typically where you have something called unjust enrichment. The enriched party is not held liable in some certain circumstances or situations. We use, because of our objective theory, we use the plain language rule. And we're going to enforce it, or a court will enforce it as written, assuming that the terms are clear and unequivocal, which oftentimes they are not. An ambiguity means something. Unclear can be either vague or ambiguous. If a term is susceptible to more than one interpretation, it will be ambiguous. Right? If it means two different things, ambi means both. So if you're ambidextrous, you can use both hands. So ambiguity, a contract is unclear, ambiguous, where the terms could be interpreted two different ways. At that point, you might be able to bring in extrinsic evidence. At that point only, you might be able to bring in extrinsic evidence. We have some other rules too. You should read through these in your text. We want to give an effect to every word or every term in the contract. We interpret contracts as a whole. And in the olden days, you had a form that would be printed, and then you would have spaces that could be typed. So you could type information into the spaces, and then some people would handwrite or initial things. So if it is a form in those olden days that was pre-printed, anything that was typed takes precedent over the form. If you typed it, if you went to the difficulty of actually typing in a term and it contradicted the form, the typewritten extra part, the conflicting part would rule. It would take over. And then if you hand wrote in something, that would trump both a typed and a form, pre-printed form. Now today with word processors, sometimes this comes into play, sometimes it doesn't, but there's a hierarchy. We try to give words their ordinary meaning. But like I told you earlier in this semester, the word damages with an S means money, whereas damage means harm. So we use terms if they are legal terms, we give them legal definitions. If they're not, we try to give them their ordinary common meanings. And again, written or typewritten give greater weight than pre-printed, and handwritten better than typewritten. If you have an ambiguity, a true ambiguity, it's a true ambiguity, it will be interpreted against the person drafting. So it's going to be in the favor of the non-drafter. Express terms are always given the greatest weight as opposed to performance or course of dealing and custom, but you can have an interpretation called an interpretatio praeter, which is you use extrinsic things to interpret terms. So if you have a written contract, but you behave in such a way that although the written contract is ambiguous, for 10 years in a row, you behave as if it's the interpretation A, the court will give it interpretation A. So it's interpretatio praeter, or interpretation outside the terms. But typically, express terms are given the greatest weight, and then performance, the way you performed it, would help us interpret the terms, and then a course of dealing in the past would help us interpret terms, and then even trade usage or industry standard, how they interpret it. As you're thinking about contracts, we're going to come back in, and we had a very high view. We're going to go back in and spend chapters on each element. So this is an interesting section of the law for me. I love contract law. I love it. It's so fun for me. It may not be fun for you, but hopefully you will learn a lot, and this will be immediately beneficial to your life. And then hopefully will also help you in some other classes as well.